Welcome to a special edition of The Point of View. Tonight we're coming to you from the office of Deputy Attorney General Alfred Tuah-Yeboah. Big issues. Adisadel assault, AG has asked the police to investigate what's going to happen. Cecilia Dapaah matter, how interested are they? Running stories on Gyakye-Quayson and co. All of that coming up in the next 55 minutes. If you like this video, please subscribe to our channel and share as well. Welcome back to The Point of View. So tonight my guest is the Deputy Attorney General and Minister of Justice, the Honorable Alfred Tuah-Yeboah, who's been in the news this week speaking to media men because it's been a busy week in court. Honorable, thanks for joining us. Good evening.
Good evening.
Your work seems very interesting. Since we came here, we've seen a lot of people in and out of your office. It looks like a very busy position.
Yes, it's a busy office. But before I even answer that, I would like to welcome to the Ministry of Justice. But this ministry is a professional ministry. It's manned by a professional lawyer. The deputies are professional lawyers. And people are able to assess our competence or otherwise based on the kind of service that we render. So if you come here on each or any other day, you see us combing through the laws, rendering legal opinions, just like any private lawyer will be doing. So it's a very busy ministry. And from Monday to Fridays, every day we're on the move.
Does the fact that the president himself used to be an attorney general make it any tougher? That so he probably watches the news and he listens to you, and if your law is not correct, he may call you directly.
Definitely, because the president is an astute lawyer, so he can directly assess our competence or otherwise. Apart from the president also, you have other ministers and other officers who are also lawyers. So it's a ministry that if you are in, you should be able to do things right. Otherwise, any other person can assess you.
Is there division of labor in the work? You know, in certain ministries, you have Deputy 1 and 2. Since law is so broad, is there a sense in which the AG himself deals with some matters? You being, I think you are Deputy 1, deal with some kind of, can you give us some insight into that?
All right, yes. AG is the head of the office. And there are two deputy ministers. I'm the first deputy minister. Then my sister Dinah is the DAG 2. Now, if you come to this ministry, there are divisions. We have the criminal division or the prosecution division and then the civil division. So I'm responsible for the criminal division or the prosecution division. Then my sister is also responsible for the civil division. But there's a third one, which is the drafting division, which technically is also under the civil division because they draft all the laws. When it comes to drafting also, we've had something that AG person takes interest in, but I also at times given the duty to also look at that aspect as well as my sister Dinah. Then you also have instances where you have the human rights, that's also part of the civil division, energy division. So there are various divisions within the ministry. But the Minister of Justice, Honorable Gyakye Dame, has made sure that two of us will be able to cover all the areas within the ministry. But he's a person who goes through everything.
This has been a very interesting week. So what you just said even sort of explains this. There's been cases in court that are being dealt with. There's been actions in Parliament because the private members bill that you can say repeal the death sentence also went through this week. And then there are police issues that you have been referred. So this is a very interesting. So let's start with the most recent, Adisadel College. This will not be the first time we've seen video coming from a secondary school. Why is the department and the AG in particular interested in this to the extent of directing the police in Cape Coast to actually do an investigation? What is it about this video that makes it so important to the department?
I would say it's because of the power of ICT. Because the landscape has now been opened because of people can just record and share videos. And I also need to indicate that it's not the first time that you see instances in schools, juniors being in quote, being disciplined by the seniors, not disciplined in the sense of how we understand it. But this particular instance, we have the visuals that you can see and look at the way the young man was maltreating the other. So having watched it, AG thought twice that it doesn't matter where a crime is committed. It can be committed in the school, it can be committed outside the school, it can be committed in the church. So we decided that notwithstanding the fact that it involved students, there's a need for us to go into it to see whether there will be evidence for us to take the matter to court and prosecute the same.
So without prejudice to whatever disciplinary action the school authorities or even the GES may take, the department is of the view that the prima facie evidence seen in the video is enough to warrant an investigation for possible criminal trial.
Exactly the point. Because if you look at it, unless fine, you have to stand, so people may say people may want to doctor videos. That's the essence of the investigation that we said the police should conduct into it. If it's established that indeed that was exactly what happened, then we'll be under a duty to make sure that justice is done. And let me let the public know that when it comes to prosecution, it is the duty of the AG to prefer charges and push accused persons or suspects to court. But the police always are there to do the investigations on behalf of the Attorney General. So as and when there's a need for us to go into a matter, the Attorney General just goes in, picks up a docket, and then we proceed.
Without prejudicing the investigation, we are told that because this is a secondary school, it is likely that people involved are juveniles. They may be under 18. Does that change the texture of this in any way?
It doesn't change it, but when it comes to punishment, it changes it because when it comes to the Juvenile Justice Act, if you're even convicted, there's a maximum sentence that you can be given. And so if they're actually juveniles, as you suspect, they'll be taken to a juvenile court, and the juvenile court will have to deal with them. And then if they are found guilty, the court will have to then punish them in accordance with the Juvenile Justice Act.
Some people feel that the way the media has even covered the story may even be violating Section 3 of the Juvenile Justice Act because they are publishing the video on TV. Photographs of some of the minors are in the newspapers, and I'm told that that is not appropriate per that section. How do you plan to address these potential violations while also ensuring that justice is done? Because there's also a view that this case is a high-profile case that you must use to make an example to curb bullying. So how are you going to balance that with the previous point I made?
Yes, if you look at the Juvenile Justice Act, if a juvenile is involved in any criminal activity or is alleged to have been involved in any criminal activity, you don't have to show the visual, the faces and everything. But we are in an era where people, because of social media, you just have it and you cannot control it. So in terms of the section in the criminal justice, we need to look at it once again. But if, for example, CCTV decides to show the video, showing the face of this boy, that's what we can complain. But those who post them on Facebook, Twitter, and the rest, we cannot even get them to complain. But there's something that we all have to look at because it's part of our laws. We need to protect the identity of juveniles who are alleged to have committed offenses.
So can I say that the AG is determined, if investigations show cause, to make an example with this case to curb what we are told is rampant bullying in our senior high schools?
We need to set an example. As I said, at the time that we were in school, we had that kind of bullying, but those times, because we didn't have cameras around, phones around, people were able to escape punishment. But this time around, we have these visuals, and we may want to go to the bottom of the matter. If they are found guilty, they have to be punished in accordance with law, so that other students will also learn from it.
I'm told in other jurisdictions there are specific laws that are crafted to deal with bullying in schools, which are specific bullying laws. I sense that you may be proceeding on this with either the Juvenile Justice Act or the Criminal Code. Do you think beyond that we may need to be thinking about specific laws within our schools now that free SHS is in, the teachers are outnumbered, the students are so many, that we may need more tailored laws to deal with bullying in secondary schools?
I think this one is a very good suggestion that we need to look at. We don't have specific laws on it, but we have general laws. For example, assault. So even if we don't have that specific law on bullying, we may want to rely on assault to prosecute them. But the suggestion that we may want to look at and see how best we can have an act, if possible, to cover students, so that we can have a whole lot of things when it comes to punishment. We may want to say, fine, if a student commits this offense and you are taken to court, perhaps you are going to be given because you are going to be given A, B, C, D punishment. It's something that we need to bring on board, see how best we can.
And again, sorry for pushing this, but without prejudice to what you decide to do, there's another view that because this happened in the school, the headmaster, the school may even have some liability under tort principles. So that, again, I don't know how you are going to proceed on this, but people say because of the systemic nature of bullying, we may have to also bring the school in, because if I send my child to a school and this happens to them, the school has a certain liability in terms of allowing this to happen to my child. So I don't know how you're going to treat this. How broad are you going to expand this? Because you want to use this as a case in example, should we expect the scope should be much wider than just the individuals involved.
Exactly what we are going to do. We are going to conduct extensive investigations, because it's possible that you may not be part of the actual assault, but you might have abetted the assault. And so if we're able to find within the line that individuals abetted, by abetting it can be by action or inaction. So let's see how the investigation goes. I don't think there's evidence that any other person will have to be prosecuted. We will do so.
You give them up to Friday. Any sense that they are making progress?
Definitely. By Friday, we'll have the docket with us, and then we'll proceed from there.
Final question on this one. Generally, when you watch the news, there's a lot of lawlessness in our schools. Yesterday, there was a story about Wa Technical Institute, 3 students beating up a teacher. Some people in the sector feel because of the absence of corporal punishment, students are becoming more difficult to manage. What are the department's thoughts around corporal punishment and its possible reinstatement in our educational system to bring back discipline?
This is an interesting debate. I remember some time ago, I engaged in this debate with some students that I was teaching. And I posed the question, now, is it the case that because we've just done away with corporal punishment, that's the reason why students are not disciplined in school? I had 2 views. Some people saying yes, others saying no. But honestly, we need to look at that aspect of punishment once again. I do not think that we can discount this kind of punishment in our scheme of things, looking at the landscape that we are operating. At the time that some of us were in school, we had teachers who were just exacting such punishment on us. Some of us were still, I'll not say me, we had seniors and other colleagues who were still recalcitrant despite the...
So you were a good boy?
Oh, I was a very good boy. I believe we'll talk about that later. So corporal punishment is something that we need to look at. I know Ghana is a state party to a lot of international treaties. One of them being the International Covenant on Civil and Political Rights, International Covenant on Economic, Social and Cultural Rights. Then we also state party to the rights of the child. If you take the CRC, that's the Covenant on the Right of the Child, there are provisions on corporal punishment and the need for state parties to do away with them. And that's the basis of our problem now, where people are not being disciplined in accordance with the old practice. But we may have to look at it and find a way of
blending international standard with our own cultural values.
Exactly.
Well, let's come to the second big issue, Cecilia Dapaah. The police issued a statement yesterday that they have submitted a case docket on an investigation into a case of stealing reported by Mr. Daniel Osei Kufuor and Honorable Cecilia Dapaah. Now, what I find interesting is the police is telling us this after the matter appears to have been in the public domain, possibly through the courts, because the documents that the media cited are court documents. Is it regular for a matter to, this is a criminal matter, to get to court before the police is now telling the public that we have forwarded the matter to the Attorney General? It seems that the sequence is a bit confusing.
Yes. If you take the practice here and you take our laws as well, the AG's office or the Ministry of Justice is not like the Department of Justice in the US, where they investigate and prosecute. In Ghana, you have the OSP. They have their own investigators and they also prosecute. But the AG's office, we do not investigate. So we rely on the police to investigate. At times, we rely on YOCO and other state bodies. When it comes to prosecution, because the AG cannot prosecute all the cases, the police have been given that kind of fiat to prosecute on behalf of the Attorney General. But we also know that if you take our constitution, when someone is arrested, the person cannot be kept in custody for more than 48 hours. So in most of the instances, the police may want to go to court, either remand or get bail for the accused person, then thereafter notify the Attorney General about the pendency of a specific matter. But I can also assure you that over 70% of the cases that go to court go without even the Attorney General knowing, because it's presumed that the police will be doing the right thing. But there are specific ones that the police cannot take to court or prosecute without the Attorney General's express consent. For example, first-degree felonies like murder, rape, defilement, there's some second-degree felonies dealing with narcotics and the rest. But in this particular instance, the police decided to do what they are supposed to do. As we all know, they conduct their own investigations without the Attorney General knowing. Then they decided to go to court. Then there was a publication. Now, The Attorney General reserves the right to write to the police for a docket to be submitted to him at any time. The police also have that kind of duty to submit any docket that they think is of interest to the public, to the Attorney General for advice. So in this particular case, the police on Monday forwarded the docket to the AG for us to review same and offer an opinion on it. So it's a standard practice that the police usually go through when they're handling case on behalf of the AG.
But if you look at the high-profile nature of this case and how it has been colored by the media coverage, does that not place the AG in a difficult position?
Not at all. Yesterday I explained to another media station that if you look at this particular case, the accused persons in the case are not public officers. They are not political appointees. They are people who have been arrested on the complaint of a former political appointee and the husband. So in terms of looking into the substance of the case, we are not going to deal principally with the political appointee, but the accused persons. We have to examine the complaint to see whether indeed there is sufficient evidence on the docket to even warrant the prosecution of the accused persons. We have to examine to see whether there's any to even add more charges or to even drop some of the charges. So we are not in any type position. If you come to the ministry, apart from the AG, myself, and then my other sister, all the others are public servants. And in terms of the review of dockets, it is the duty of the Director of Public Prosecution, together with the other lawyers there who do it. So as we sit here, they are in their division working on all the dockets. We only come in when they finish and say, boss, this is what we've seen, how do we do it? So we've given them that kind of latitude to operate. So that's how it works. So it's not going to be a bother to us. We are going to do an independent assessment, devoid of any kind of consideration, to see the merits of that particular case, to see whether to prosecute or not to prosecute.
But we do know that there are instances where a complainant can become the accused and vice versa. And in this matter, it appears the quantum of money stolen, the fact that it was in the public officer's house, has generated a debate about the conduct of the minister herself. Now, the OSP is looking into the matter, but ordinarily, would this have been of interest to the department? So yes, a police has asked you to look into a theft case. In looking at that, would you have said, by the way, how did this amount of money end up in your house? Is that part, who defines the remit? Is it just the police telling you that, well, we are prosecuting a theft case? Or in seeing the case, can you raise other cases?
Yes, it is within the purview of the investigators to go into any form of investigation they may want to do. So if, for example, I report that my gold, maybe 300 bars of gold, have been stolen, in their investigation, they want to question me whether indeed I had that 300 bars of gold. But if I say, yes, I had it, the police also, they are also a state institution. They may even want to involve the GRA to find out whether indeed I have been paying my duty as a citizen and whether I have been declaring my income in accordance with law. So the police, they can play around it and then go into any part of the case. And as you said, the OSP is now handling some aspect of that case, corruption and corruption related. So it's now within their remit to look into that. But that does not stop the police from also doing further investigation. If required, that they should do further investigations.
But does the OSP stepping in the case preclude the department from expressing interest? Because I stand to be corrected, but we know there have been cases where both the AG and the OSP have been interested in a particular case.
Yes, this is an interesting question. If you look at the OSP Act, we have given the OSP part of our constitutional function to prosecute. And that portion that we've given to them relates to corruption and corruption-related matters. Other persons may argue that the fact that we have given them that power does not mean that we cannot exercise the same power when it comes to corruption and corruption-related matters. For example, you may have one accused person in a series of events committing maybe stealing, robbery, assault, and also corruption. In that case, if you're looking at the law as we have it now, you may want to decouple them, deal with the ones that we can do, and leave the rest to the OSP. The person is a public officer. But I don't want to answer that question directly as to whether we may want to go into that. But the practice as we have it now is that when the OSP is going into a matter within their remit, we have to stay off. because that there's no need for us to have that kind of conflict. For example, it's corruption and corruption related. We need to let them know. But if you're also doing the investigation, the police are doing on our behalf, we may want to look at the areas that we think we can also prosecute in court.
So when should we expect the advice on the substantive case, the theft case? Because I think the police sent their release yesterday. And because of the high nature of public interest, is this something you're going to finish within the week?
I can assure you we are working earnestly on it. And within the shortest possible time, we will come out with the opinion on the matter and send to the police to carry on what they were supposed to do. So it's a matter that we are not going to say it should be one of those matters as usual. The public, because I can see, I'm a member of the public, you're also a member of the public, we're all interested in getting to the bottom of the matter. So we are doing what you
Just a final point. The minister herself has, in a statement before her resignation, sort of questioned portions of the account in the public discourse traceable to what the police put on the charge sheet. Because in her statement, she says that the amount being referred to in the charge sheet is not the same as what was originally complained about. Is this of interest to you? Is this something you feel the AG can come in?
Fortunately, we have the original docket. We have the original complaint. We have all the statements that the investigators took from other people who were supposed to be interrogated. So we are going to examine everything, then come out with a statement on it.
My final question on the Cecilia Dapaah case is in relation to the bill for the Code of Conduct of Public Officers. Now, we without prejudice to what the OSP finds, and we haven't said she's done anything unlawful, there is a view that not everything wrong is illegal. So something can be morally wrong, but legal.
Yeah.
Some people think that the 2022 bill for the Code of Conduct of Public Officers addresses some of those matters. But this government has been very slow. In fact, Cabinet did not think we needed a new Code of Conduct. They thought Act 550 was enough. I don't know what this department thinks, because there are so many loopholes in Act 550. For example, if I file my,
Asset declaration.
Declaration, I'm given a certain 6 months to actually do the filing. And that lacuna has been used by many public officers not to file or to do that. Is the AG's department committed to passing this Code of Conduct to amend Act 550?
Yes, I think we've done extensive work on that bill. We've held public engagements. We've held a lot of discussions, and the final draft is before Cabinet. So if Cabinet approves the final draft, then we have to go back to Parliament for it to go through the process. But I can tell you that if you look at the bill, it deals with a whole lot of things. That if you're a public officer and you think that you can just do things anyhow, then you should be revising your notes. For example, if I declare my asset and I go to the Auditor General's office and just dump it and I take a receipt, and the Auditor General is able to have access to it, it's possible that I may even say I own 10-story buildings in Sunyani in that asset declaration. So when I assume the office, the only thing I will do is that I will just work towards getting that asset. If you request me, I'll tell you, go and open my. So there's a need for a verification process. It's part of this bill. The issues about gifts. People move around. You tell them that, oh, we had this kind of gift. So 50,000 Ghana cedis gifts. What are the laws on gifts? There are provisions on this particular bill. So it's our expectation that Cabinet to go through the process, and then we will take it up from there.
How confident are you? Because as early as February this year, Cabinet, in a response to Occupy Ghana's letter, said they thought that there was enough leverage in our existing Act 550 for the conduct of the public officers. So Cabinet did not think it was necessary to move the bill forward to Parliament. In fact, it's only after the IMF program and their insistence on us making our public officer code of conduct more robust that we seem to be interested. So is it that this department thinks it's a good law, but when you go to Cabinet, you are outnumbered?
Oh, no. We see that as one of the good laws you're going to have if we pass it. Cabinet has also gone through that one. But in any event, if you go to Cabinet, it's not something that you take it there and it goes through just like that. There should be that kind of discussion to see the merits and demerits of it. But as I told you, government is committed to passing that bill. If government were not committed, I don't think we'd be wasting all this time drafting the bill, going through public engagements and submit. I have worked on that bill, and I've even engaged Commission on Human Rights and other anti-corruption agencies on that bill. So I'm very sure that that bill will be passed.
This is the point of view. My guest is the Deputy Attorney General, Alfred Tuah-Yeboah. We've been talking about the big stories for the week. Adisadel College, AG is interested, police are investigating. They want to make an example on this matter. On the Cecilia Dapaah case as well, they will give their advice. And you also heard it here first, that government is committed to passing the Code of Conduct Bill. This is what the minister is saying. When we come back, there are other issues to look at. Stay with us. Welcome back to The Point of View. Tonight, we are privileged to be talking to the Deputy Attorney General and Minister of Justice, the Honorable Alfred Tuah-Yeboah. We are discussing most of the issues that have popped up this week. We know of the Adisadel bullying video. AG has taken interest in that. Also, the Cecilia Dapaah matter. OSP is involved. AG is involved in some aspect of that. The other big story this week has been the repeal of the death penalty, for want of a better word. Now, it still exists in some form or shape. But I want to just pick their thoughts on this. He mentioned that drafting is part of the work they do. So, how much of a victory is this for the department as well? Because this was a private member's bill, which the civil society group supported. Just explain the role of the AG's department in getting this death penalty repealed.
Yes. Usually, as we all know, before any bill is processed, it will have to come from the executive. But per our constitutional architecture, it's also permissible for a private member to initiate or to have such bills initiated. And the bill, which was just part death penalty, was initiated by members of parliament. Usually when they initiate it, they have their own drafters who draft the bills there for them. But to make sure that it's in line with standard clauses, they usually refer such bills to the ministry for drafting, which we also go through and then make various comments. So that's the process that this particular one went through, just like the LGBTQI. So after going through that process, then it's laid before Parliament, the debate ensues, then you have the bill being passed. So whether it's a private member's bill or it isn't, this office is always part of the process because we may want to have the laws in the standard form.
Does the department support the bill?
Yes, the department supports it. And in fact, he says the president, I think 2 or 3 months ago, made it clear that he's in support of the bill to abolish death penalty in Ghana. So that's why it had that kind of bipartisan support in Parliament. Though I concede that there were other members from both sides who were against that bill. That's another debate we have to look at. But in terms of the support for it, the president and the government is in support.
But technically, even though the death penalty has been repealed, it still exists for treason and coups, attempted coups, because Article 3 is an entrenched provision. So are there plans to amend that to then eliminate completely the death penalty?
This one is the first step. I think the second step is a bit difficult, a bit tedious, because it is an entrenched provision. You have to go through a referendum, you know the threshold that you have to meet. So maybe if you may want to amend our constitution, you have to look at that provision in the constitution. But if you're unable to meet the threshold, it means that you have to stay in our statute books.
So technically, the death penalty has not been completely repealed.
It's partially repealed.
Partially repealed. So that's a very important distinction. Yes. So, but based on what you said, the president will sign when it gets to him. You have no doubt.
I have no doubt. Unless, of course, the bill comes and he has some doubts about how it's been done. He reserves the right to refer it back to Parliament for them to reconsider. But from what the president has actually indicated to the public, he's in support of this
without repeating the debate around it. We listen to people who say this is not a good thing we've done because there will be an increase in violent crimes, because of the repeal of the death penalty, because they see the value of the penalty on the statute books as a deterrent to certain kinds of crime, particularly murder. So now for murder and attempted murder, death penalty doesn't apply. What's your response to that?
Yes, I think that it's a very good and healthy debate, because you have two sides of the same coin. And those who give out that argument, they are able to substantiate it with data. Those who also think that it must go, are able to substantiate the arguments with data. Since we now have the bill passed, let's start the implementation and see how it goes. If in the course of implementing it, you realize that it's not going the way that is expected to be done, and the people of Ghana are also discerning, Parliament is also discerning, we may want to review it. But as it is now, the debate has gone on. Majority of Ghanaians, I say majority of Ghanaians, through Parliament, have approved this particular bill, so we may want to go with it.
Final question on this. The Article 108A, which is basically of the Constitution, says that a bill which is from a private member shall not impose a financial implication for the state. There is a school of thought that this bill, because you have repealed the death penalty, you may have to spend money on keeping people who are supposed to be executed alive and fed. So indirectly, it imposes a financial obligation. So if somebody decides to go to the Supreme Court to challenge the constitutionality of the bill, as has been done with the narcotics bill, what will be the mindset of the department in defending this? Because some people strongly think that this bill has financial implications for the state.
That's been an interesting matter. If you look at the Constitution, the decider of whether that bill has financial implications on the consolidated fund is the Speaker of Parliament. He exercises that discretion. So question, can that discretion be questioned in court? That would be one of the issues. And is he supposed to act anyhow in exercise that discretion? That's one constitutional matter. Because if you have a discretion, you must exercise it within certain limits. So it will be within the right of any person to test it in court. But since the Speaker has admitted it, indicating that he doesn't see any problem with it, that's how we have to take it now, unless the courts come to a different conclusion.
Another bill you referred to was the LGBTQ bill, which we understand is in the second stage of Parliament. Last year, November, your boss said that sections of the bill were unconstitutional. Has the department intervened in tidying up the bill in the current state that it is in? Or is it Parliament that's going to do that?
Yes. The Honorable AG appeared before the Constitutional and Legal Affairs Committee of Parliament. I was there with him. He stated his opinion on the bill. Fortunately, most of the issues that he raised were given assurance that they had already taken into consideration those issues. So the bill as it is now, it's our expectation that it will be cleaned up. Unless, of course, in this fund, because it's now that we're going to take clause by clause debate. That's the third reading. That's where every clause will have to be looked at to see whether, but with the meeting that we had with the committee, we think that this.
So you expect the committee to implement your concerns before it gets to the third reading?
Yes, because if, as I said, they said they had done it, and we are very sure that they've done it as they said. But if we get to the floor of Parliament, and there are issues about the clauses once again, members of Parliament may raise it, and they may want to amend those clauses. So it's something that I think Parliament will have to look at it, and I actually expect Parliament to do the right, and they will definitely do the right.
Is there a sense in which the AG and government feels railroaded by this bill? Because I remember the Speaker asking if anybody was against the bill, and there was absolute silence. It appears for the first time, this very divided Parliament was absolutely together on this bill. Yet Ghana is signatory to many international conventions, some of which are human rights related. So is the department conflicted, where the Parliament is determined to pass the bill, and you being the custodian of some of those conventions is trying to tidy it up, but you are politically in a difficult situation to do that?
Actually, we are not in any difficulty. Ghana practices majority democracy. When it comes to what people, the majority, what they say is what should actually be implemented. And so if you step out right now and you spoke to about 10 people, I can assure 9 of them will say this bill may have to be passed. So meaning that if Ghanaians, over 90% of Ghanaians are in support of the bill. If you take international instruments like, or treaties, I've actually not cited any provision in any international convention or treaty to the effect that we should respect the rights of LGBTQI. I've not cited it. If you take the African Covenant on Human and People's Rights, it talks about family values. It talks about the family being the unit of our society. So Africans within the family, how do we beget families? So that is the jurisprudential base that Ghanaians are in for this bill. It does not flout any international convention or treaty. Rather, it enhances the cultural values of Ghanaians.
Let's talk about the Gyakye-Quayson trial. Has the daily trial actually positively affected the case in any way? Because, look, defense has been spending over a month fighting, and the state's first witness is yet to be discharged, right? Ostensibly, the reason for even wanting this to be done on a daily basis was for dispatch. And I can argue that today is 27th.
Yeah.
Gyakye-Quayson was voted 27th of June, a month ago. Nothing has happened particularly substantively on the case. So did we go or did we come?
Yes, this particular matter, it started in January 2022. So it's been 1 year, 7 months. And if you have a case in court, 1 year, 7 months, and you have only the first witness being cross-examined, then it tells you how the case has delayed. Now, the court made a ruling that it may want to have the matter heard day to day. If a court makes an order and you disagree, you have the right to appeal against that order. And I think Gyakye-Quayson and his lawyers, they are of the opinion that the judge erred in making that order. We disagree with them. You go to court and they file a process seeking to challenge that order. You have no option than to also respond for the court to give its ruling. So it is true that for the past 1 month, actually, you've not done much, all because of this, what some of us would say, legal gymnastics. You may want to take advantage of a certain law, which is permitted. We have to also meet. For example, we're in court today, there was another application, we responded and they lost. If you go to court on Friday and they file another one, we have to also respond to them. But you do all those things, you get to a point where you end. And so we are unfaced.
But January 2022 to now may not be the longest. Oponi's case has dragged longer. The death of J.B. Dankwa-Edu, much longer. There have been cases, the Gregory Afoko case has been much longer. How do you convince Ghanaians that you mean well when you are applying the standard of daily trial to a highly political case, and yet for other cases that have dragged longer, you haven't thought it wise to do it so? Now,
if you take murder cases, they are tried by a judge and 7 jurors. All of them are present at the same time for proceedings to commence. And so if you go to court and one of the jurors is bereaved, is sick, has traveled, it means that you have to take an adjournment. So when it comes to the trial of those cases, it means a lot. In the advanced world, because of their system, when they're able to do everything, they say, for example, 2 weeks, the jurors are kept, the matter is heard, and judgment delivered. But in Ghana, that's not strange because of financial difficulties. So that's the reason why if you take those first-degree felony cases, it takes a whole lot of time. Even if you are trying the case, in murder cases, and before you even finish the matter, maybe you've taken evidence from prosecution, they've closed their case, the accused person has testified, the court has even summed up the evidence, and one of the jurors passes on, you have to start de novo, start afresh. So that's a case in a different realm. But if you take second-degree felony like stealing, causing financial loss, perjury, those offenses are tried by one judge. So that judge is able to have time to hear the matter expeditiously, unless he's sick or he's been transferred. So that's the difference between this particular case and those high-profile.
What about the Oponi case?
Oponi, how many years now? 2018, the state has called, if I'm not mistaken, the state called over 11 witnesses. And Opuni, you have about 4 accused persons. Each accused person has a lawyer. He has the right to cross-examine one person. So, for example, you take witness A into the box. Counsel for Mr. Opuni will cross-examine him. Counsel for Mr. Sedu Agongo will cross-examine. Even the company, Agricourt, will also cross-examine. So it takes a whole lot of time to do it. So anytime that you are prosecuting multiple accused persons, it takes a lot of time.
So what is the public interest benefit of trying Gyakye-Quayson every day?
You see, if you take Gyakye-Quayson's case, he's not the only accused person whose case is being tried daily. If you go to the court, I may want you to maybe do that kind of investigations. If you go to the high courts, you get many cases where the accused persons go to court daily. Because when you start the trial, the case can be pending for a year. You've not started the hearing. But when you start the hearing, most of the judges may want to hear the cases expeditiously, but subject to availability of time within their calendar. So if you are fortunate to have a judge whose court has a lot of time to spare, and he says, I'm ready.
But he is an MP. So he must balance public policy because he's a member of parliament duly elected. So if you are saying you should try the case daily, and parliament sits 4 days a week, sometimes 5 days, you know that you are depriving his constituents of representation. You cannot be oblivious to that.
But you see, the farmer who is also being tried, the farmer, or the teacher who is also in the classroom, or the accountant who is working in another office, are they also not workers?
Yeah, but that's why when a member of parliament is on his way to parliament, sometimes he's protected from even arrest because the duty of MP is not the same. You cannot equate all their duties. So yes, everybody's job is important, but the law makes provision for lawmakers because of the sensitive nature of the job they do.
It's true. You started the example of the MP going to parliament. He can be arrested. He cannot be served with a process seeking to arrest him. Meaning the person cannot be served with a warrant that will under arrest. But the police officer on the spur of the moment can arrest him because arrest is either by a warrant or without a warrant. So if you look at that provision so well, we realize that it is not true that an MP cannot be arrested on his way to parliament because there must be a process being served on that MP. And the police may not serve any process. So for example, you're in traffic and you pull your pistol and shoot someone as an MP. So the police will have to wait for you, so you're going to parliament, so they should not arrest you. So this one is a bit deviation. But the whole thing is, whether you are an MP or a non-MP, that's what we call equality before the law. The judge has even made it clear in this particular case that the fact that she said the case was going to be heard day to day doesn't mean that every day they will be in court. In fact, she made in one of the rulings that it's possible that you may even go to court and then there's a letter from the speaker. Just like when he was about to be sworn in, the speaker brought a letter and we had to adjourn. It's possible that the judge herself may not sit, the lawyer for Mr. Quayson may not even be well. Mr. Quayson himself may also not be well. So there are instances where you may have excuses. But the principle is that if there is available time, you have to hear the matter day to day. And since that order was made, as you said, you've not been to court even on 3 consecutive occasions.
We'll take a break. We're still talking to Deputy Attorney General on a lot of legal issues. Stay with us. Welcome back. We're still talking to Deputy Attorney General, the Honorable Alfred Tuah-Yeboah, here in his office on a number of issues. We'll finish with the Gyakye-Quayson and move to a couple of quick issues as well. There have been reports of, or claims of a government-sponsored attempt to remove the Domahini from office as judge due to the critical comments he made about the trial of Gyakye-Quayson, where he advised your boss to file a nolle prosequi. What are your thoughts about this?
I think there's no basis for anyone to think that this government may want the judge, who is also a distinguished paramount chief, be removed from office. No. He made a comment. He made a suggestion. And that comment may either be accepted, or that suggestion may either be accepted or rejected. So far as we are concerned, the Domahini is an accomplished Omahini. He's also a sitting High Court judge. Nobody is been contemplating doing anything to him. But if within the space that he operates, there's a border may want to find out from him, that's another matter. But so far as the government is concerned, that interest doesn't even arise at all.
But I think the AG did comment after the Domahini statement that people should be careful in making prejudicial comments around ongoing cases. And that was interpreted to be an attempt to gag press freedom.
No, you can comment. It was a caution. You can comment on pending cases, but your comments should not suggest that you are trying to prejudge that particular case, or you are making some comments indicting a judge. So I think these are within the parameters within which the AG made that comment, and a statement was issued. We have the right to pass comments. You can run commentary on it, but you make sure that you don't go beyond.
So where is too far? Because the former AG, Gyakye-Quayson himself, did say that he would advise the current AG to file a nolle prosequi.
It's an advice. It's within his remit. It's
so
an advice.
Does that prejudice the matter?
No. Because that comment that he passed or he made, it was something, it was an opinion.
But people came out to condemn the Domahini.
That's another matter. That's why, so far as we are concerned, we don't even want to zero in on the paramount chief. No. It's about general comments. And we think that you can pass the comments. By in passing the comments, you must also have in mind that there are parameters within which you may have to stay.
In December last year, Atu-Quayson was convicted. Sorry, Atu-Essien. Forgive me. Atu-Essien was convicted of misappropriating Capital Bank's liquidity fund. And then the department came up with, so he was convicted. But in lieu of a sentence, you came up with a plea bargain, which appears to be one of the achievements of the department. He was to make payments in April and July. At least he was making a payment in July 4. Has he paid? If he has not, is this not flying in the face of your plea bargain innovation?
Yes. As I speak now, Mr. Atu-Essien has not made the payments that he's supposed to be making.
90 million restitution.
90 million, he paid 30 million down payment. Then subsequently, he was supposed to have paid 20 million at the end of April. That amount, he's paid 8 million. And he was supposed to also be paying 20 million at the end of August and then December. So he has defaulted. We are supposed to be in court tomorrow. The last time we were in court, the judge said he was given the last opportunity to see whether he can redeem himself. So if, for example, we go to court tomorrow and he's paid, case ends. If he has not paid, we will insist that we are permitted to move the motion seeking to have him sentenced into prison.
But you are conflicted because I feel the AG's department wants to make a case that plea bargain is working. And this is a high-profile case because the prisons are congested. And yet, his inability or failure to pay undermines that.
I agree with you. You see, we thought that having taken advantage of Section 35, he will stick to his words. But he has not done so. So in future engagement with accused persons who may want to take advantage of Section 35, maybe we may also want to go another way. Because in this instance, you pay 30 million, we gave you 12 months. Having learned from this in a very bitter way, we may want to look at it again when you approach us with the same system to have your case terminated.
The minority leader says that his trial is a witch hunt and he has asked the judge to recuse herself for alleged bias. What's your comment on that?
Yes. Last time we were in court, the judge said that a petition had been sent to the CJ. The petition was filed by, I think, Sedu. No, the other person with him. I think one of the other accused, but the minority leader has also filed a motion. Tomorrow will be the day that will be in court. We don't know whether the CJ has reacted to that petition. So depending on what the CJ says, then we may want to know what we have to do. But nobody is persecuting him. In actual fact, his case started last year in court. And I may have to commend his lawyers also. The state has been able to we called about 5 witnesses and close our case. They've even opened their case and called 2 or 3 witnesses. So it's not about persecution, it's about rule of law. If at the end of the day, the court comes to a conclusion or determination that Atu-Quayson is not guilty, so be it, that's rule of law. If the court says he's guilty, that is it. So there's no inclination on our part to persecute him, no.
What about Collins Dauda?
His case also in court. Today or yesterday, the prosecutors went to court. The case will be starting in November, I understand. Here will be starting in November.
There's a view that there are so many cases that could have piqued the interest of the government, which would probably involve MPP officials, but you have not thought it wise to persecute any of them. So the NDC, indeed, they released a statement a couple of days ago, basically saying that the MPP was witch hunting their members.
If they can cite examples, I'll be happy. If, for example, they can show Mr. A or Madam B was alleged to have done ABC, the state has not taken any step, then we'll be entering into a healthy debate. But if you just put it there without any basis, then responding to such a statement will be a bit difficult for me.
But you understand that the Quayson trial particularly is affecting the work of Parliament because of their boycott.
I don't understand. You see, why didn't they boycott when their leader, my not leader, was undergoing prosecution last year up to this time? Mr. Collins Dauda, alleged Collins Dauda, his case started 2 years ago. He's been coming to court all this while. Why did they boycott?
Because they are saying that having done a by-election and having gotten the mandate of the people, to now bring a case of perjury is a stretch. They feel that you are trying to use the courts to redesign the balance of Parliament.
You see, that argument is very weak and cannot hold water. Unless they are suggesting that if you are a citizen, you commit an offense, you're able to go to elections and win. Because of that, you should not be prosecuted. Then I will agree with them. Because this gentleman was undergoing prosecution before he won the by-elections. And so if we are going to use elections as insurance against prosecution, that will set a very dangerous precedent.
But you took him on in a different case. Initially, it was about his qualification in Nimfa and Co., that he wasn't qualified. But from the record, it's quite clear that having started the election, as of the time he was voted for, he had the documents. But because of the technicality of the time he did the filing, he was thrown out. So to now have him win the election and then go and now say that he perjured the court, it's seen in whose interest? What are you trying to achieve with that?
This prosecution started in January 2022. When did we have the by-election? Just about a month ago. So if the case had been that after the by-election we are not bringing more charges against him, then this argument may hold. In any event, if you take the charge sheet, we have 5 counts or 5 offenses. The first 2 offenses have nothing to do with elections. It's about the time that he applied for a Ghanaian passport, somewhere in July 2019. He had not even applied to renounce, where he filled the form and allegedly indicated that he didn't have dual citizenship. Mm-hmm. He did this before a public officer. So what offense has he committed? We may want to press charges of deceit of public officer and also trying the offense relating to his deception when it comes to the acquisition of the passport. So these 2 offenses have nothing to do with elections. Unless people are saying that so far as he has won elections, we should forget about it. That I said, in that case, the gentleman who's also staying somewhere may say, oh, now that I've gone to rape this lady, let me just go to my people, win elections, and they use that one as an insurance against prosecution. In that case, Ghana will not be going anywhere.
Final one is Opuni. So initially there was a judge who said that this matter has to be retried from the beginning. You vehemently disagreed with that. In fact, your boss criticized that judgment. I don't want to use the words they used. Now you have your way because the old matter. What is your expected timeline? Where is this case in this running?
Yes, this case, we were in court yesterday, I think yesterday. The judge has agreed to adopt the positive per the orders of the Court of Appeal. But Dr. Puni and the other accused, they've also appealed against the decision of the Court of Appeal. So even if we start, and the Supreme Court says that no, the Court of Appeal erred, then that you have to come back. That's how law works. And so anytime I see that people may want to take advantage of the law, even though it may go against me, I still say, fine, that's the way that the person wants it to go. Let's meet the person in court.
So the Lord teaches a man to be patient.
That is it. If you don't have patience, don't go to court.
Have you used ADR to settle any government case? Because a big discussion. Indeed, your second deputy is a known expert in ADR. I find it a bit surprising that for almost all your cases, you are using litigation and confrontational approach.
When it comes to criminal matters, we now have the Plea Bargaining Act, which is a law, which in a loose form is a form of settlement. If the accused person wants to take advantage of it, and I can tell you, I have written on not less than, or I've referred not less than 50 or even 100 of such applications from accused persons for us to enter into plea bargaining. And we are working on all of them. So we are interested in applying the law. But there are some offenses that you cannot activate that form of settlement process. So it's not about we always trying to be in court to fight it in the hard way. We also do it in a soft way, provided that other person may want to cooperate with us.
We'll leave it here. Thank you for talking to us. We've been speaking to Deputy Attorney General Alfred Tuah-Yeboah on a number of issues. The big story, AG is waiting for police to bring information on Adisadel matter, and they will also advise on the stealing of Cecilia Dapaah's properties. Other issues he updated us on. Thank you for watching. We'll see you next time. Bye-bye.
The Point of View is brought to you by Belpack. Belpack, just perfect.